Okay, let's unpack this. Close your eyes for a second and imagine a world where new inventions, groundbreaking designs, revolutionary processes, they're not coming from a lone genius sketching in a notebook or a team brainstorming late into the night.
Right.
They're being conceived, developed, and basically spit out continuously by machines, by artificial intelligence systems. It's not just theory anymore. Our source suggests this capability is like advancing every second. And that capability brings us face to face with a truly profound, almost science fiction-like question that's very much rooted in today's reality. If an AI system autonomously creates something genuinely novel and useful, something that meets the traditional criteria for patentability, should it be recognized as the inventor? Can it even hold a patent?
And this isn't abstract speculation for some distant future, This is a live, active legal challenge unfolding across jurisdictions right now. It's forcing countries to look at intellectual property laws that, well, in some cases, are centuries old.
Yeah.
Laws fundamentally built around human creativity and figure out how they apply, or maybe more accurately, fail to apply in an age of increasingly autonomous AI. It's about the very definition of inventorship, creativity, ownership, really fundamental stuff in a digital world.
Absolutely. And that clash, that intersection of cutting-edge artificial intelligence and established patent law, that's the core of this deep dive. We're zooming in specifically on the situation in India, but we're doing it through the lens of a particular case that became a global flashpoint for this issue.
That case involves an AI system known as DABUS.
Yeah.
It gained considerable notoriety precisely because its creators sought to challenge the conventional wisdom by listing the AI itself as the inventor on patent applications worldwide.
Right.
It put the question squarely before patent offices and courts, like, here it is, deal with it.
Exactly. We're diving into a specific source here, an article that examines the Davies case and focuses on the Indian legal perspective. Our mission today is to take that source material and really extract the critical insights for you. We want to make sense of India's current legal stance, understand the significant complex challenges that AI inventorship presents within and to that framework, and explore the potential paths forward that are being discussed.
What's truly fascinating here, I think, is how deep the challenge goes. As you mentioned, traditional patent law wasn't designed for this, not at all. It was built on the bedrock assumption that an inventor is a human being, someone with consciousness, with the capacity for inventive thought, for applying ingenuity. AI, especially systems that claim autonomous inventive capability, fundamentally shakes that bedrock. It's not just a tweak to patent rules. It forces a reevaluation of who or what qualifies as a creator in the eyes of the law, and, crucially, who is entitled to the rights that flow from that creation.
Okay, let's start by getting a handle on this DABUS saga itself. What exactly is DABUS, and what made its case so pivotal?
So, DABUS is an acronym. It stands for Device for the Autonomous Bootstrapping of Unified Sentience. Bit of a mouthful.
Definitely.
It was developed by Dr. Stephen Thaler, a computer scientist. And Dr. Thaler's central claim, the one that really ignited all the legal battles, was that DABUS had the capability to independently generate inventions without direct human guidance or assistance in the inventive process itself.
Right. That's the key part, isn't it?
Exactly. It was portrayed not just as a tool used by an inventor, but as the inventor itself.
Independently, that's the claim that caused all the commotion. It wasn't just like augmenting a human's ideas. It was purportedly conceiving the novel ideas entirely on its own. And there were two specific inventions that Dr. Thaler attempted to patent, listing Davis as the sole inventor, right?
That's correct. The source mentions two distinct inventions that were the subject of these applications. The first was described as a food and beverage container designed with a fractal shape.
A fractal shape.
Yeah, specifically optimized for effective robotic handling and gripping. Now, while the source doesn't detail the exact fractal design, you can kind of visualize something with, repeating patterns or specific protrusions and indentations tailored for automated assembly lines, making them easy for robotic arms and manipulators to grasp, move, and stack precisely. It's an invention kind of driven by the needs of automation, something you could imagine an AI trained on manufacturing processes might conceive.
A container specifically for robots. That's a very 21st century invention. And the second one?
The second invention was a unique light flashing device for emergency care or alerting. Again, the source doesn't give us the granular technical details, but imagine a distress signal or warning light that uses maybe a novel sequence or pattern or rhythm of flashes,
Yeah.
perhaps a pattern that is more attention-grabbing, more easily distinguishable from other lights, or maybe specifically designed to be interpreted by autonomous systems or specialized sensors. Something beyond just a simple on-off flash, conceived by an AI potentially analyzing patterns of visibility or human or even machine perception in chaotic environments.
So two seemingly practical inventions, allegedly generated solely by this AI system. And Dr. Thaler didn't just try this in one place, did he? He launched a deliberate, multi-country campaign to test the legal waters.
Precisely. He really went for it. Dr. Thaler filed patent applications listing DABUS as the sole inventor in more than 15 countries around the world. The source specifically calls out significant jurisdictions like the UK, Germany, the US, Australia, India, South Africa, and the European Patent Office, the EPO, among others.
Wow.
This global strategy basically ensured that the issue couldn't be ignored, and it provided a fascinating comparative analysis of how different national and regional patent systems would react when confronted head-on with a non-human inventor.
And as you might expect when you challenge established legal norms across, 15-plus countries, the outcomes were, well, not exactly uniform.
Indeed, not at all. This is where the case becomes such a critical case study in how different legal frameworks are currently equipped, or perhaps unequipped, to handle AI inventorship. The vast majority of patent offices and, subsequently, the courts in these jurisdictions, places like the US, UK, throughout the EU, and at the EPO, they denied the patent applications.
Okay, the majority said no. And the reason for those denials was largely consistent across the board.
Yes, according to the source, the core reason was fundamentally the same across these major patent systems. Their existing patent legislation requires an inventor to be a human person, or, in some contexts, a recognized legal entity like a corporation.
Right, acting for humans.
Exactly, acting on behalf of human inventors. And under the current interpretation of their laws, an AI system is simply not considered either of those. It's not a natural person, and it's not a legal entity.
So the legal definition of who can be an inventor proved to be the immediate, often insurmountable barrier. The laws were quite literally written for people.
Pretty much. That was the big hurdle. The rulebook essentially said inventors must be human, or a legal entity holding rights derived from a human, and an AI doesn't fit that definition. A clear, almost blunt legal roadblock.
But there was a very notable exception, wasn't there? One that kind of broke this pattern.
There was, and it's important. The source highlights South Africa as a significant outlier. South Africa did grant the patent listing DABUS as the inventor.
They did. Why? Did they decide AI could be an inventor?
Well, not exactly in a philosophical sense. The source explains this wasn't necessarily an endorsement of AI consciousness or anything like that, but rather a result of their specific legal system. South Africa operates what's known as a depository system for patents.
A depository system. What does that mean practically?
It means that unlike many jurisdictions like the US or Europe, where the Patent Office performs a really detailed substantive examination for things like novelty, inventive step, and often the validity of the inventor's claim before granting the patent.
Right, they check everything first.
South Africa's system, at least at the time, was more focused on accepting the application documentation as filed, provided it met the formal requirements, kind of like registering a document rather than vetting it deeply up front. And crucially, their law lacked an explicit requirement for a specified human inventor in the same stringent way others did at that point of initial filing and acceptance.
Ah, I see.
This procedural difference allowed the DABUS application, with the AI listed as the inventor, to sort of pass through the initial grant stage.
So it wasn't a deep legal finding that AI can invent and own patents under their law, but rather that their specific procedural rules didn't have the same initial block on who could be listed. It was more about the process.
Precisely. It really highlights how the nuts and bolts of national procedural law, not just the fundamental definition of inventorship, can play a huge role. The source also mentions another country alongside South Africa as demonstrating a potentially more open stance.
That was Australia, right? I recall seeing that.
Yes, the source groups Australia with South Africa as showing an openness to AI inventorship. Now, while the specific final outcome for DABUS's application in Australia might have had further legal challenges or nuances not detailed in our source, quite like South Africa's grant,
Okay.
the mere mention suggests their legal framework, or perhaps at least certain initial court interpretations, might be less rigidly tied to the human inventor only requirement compared to the majority of jurisdictions that flat out denied DABUS. It signals that some legal systems are being interpreted in ways that, while maybe not fully embracing AI as a person, are grappling with acknowledging its role differently.
So this wasn't just some interesting legal experiment by Dr. Thaler. The DABUS case had real, tangible significance on a global scale, didn't it?
Absolutely. Its significance is multifaceted, really. Firstly, as we've seen, it forced the issue onto the global stage. It stopped being just an academic debate. Patent offices and high courts in major economies had to actually make a decision. They couldn't ignore it.
Right.
Secondly, it provided a pragmatic, real-world comparative analysis. By filing in so many countries, Dr. Thaler inadvertently created this live study of how disparate national laws reacted. This immediately highlighted the existing legal gaps, the inconsistencies, and frankly, the pressing need for international dialogue, or at least domestic reform, regarding AI and intellectual property. It was a real catalyst.
Which brings us nicely to India's position in all of this. Where does the Indian legal framework stand when confronted with the possibility of an AI inventor based on the source's analysis?
Okay, so to understand India's stance, we need to look at its foundational legislation for patents, which is the Indian Patents Act, 1970. This act is the rulebook. It lays down the rules for getting and enforcing patents in the country.
And right at the outset, the Act defines who is even eligible to file for a patent. Section 6, I think. What does that say?
You got it. Section 6 is quite explicit. It states that a patent application must be filed by a person who is either the true and first inventor or someone who derives the right to apply from the inventor, like an assignee, for example.
Okay.
So that sets the initial requirement. You must be a person or hold rights from a person who is the true and first inventor.
True and first inventor. That phrase seems to carry a lot of weight in patent law generally. What does that traditionally mean, and how is it interpreted in India according to the source?
Traditionally and critically, within the current interpretation of patent law, both globally and specifically in India, as highlighted by the source, true and first inventor implies a human mind. It's about the individual who conceived the idea, the person who applied intellectual effort and ingenuity to arrive at the novel solution.
So it's tied to human creativity.
Very much so. It's tied to the concept of human creativity and mental conception, the spark of invention originating in a person's head, essentially.
Okay, so the requirement is a person who is the true and first inventor, strongly implying a human. But let's dig into that word person. What does person specifically mean within the context of Indian law? Could that definition potentially stretch to include something like an AI?
This is a really crucial point, and the source is very clear on this. It cites the General Clauses Act of 1897. Now, this act provides standard statutory definitions for various terms used across lots of Indian legislation, including the definition of person.
And what does it say person means?
The General Clauses Act defines person as including natural persons, that's human beings like you and me, and legal entities, think companies, corporations, associations registered under law.
Okay, natural and legal entities.
Right, and the source explicitly states that under this established legal definition, AI systems are excluded.
Excluded, full stop.
Excluded.
Yeah.
So right there, at the most fundamental level of legal identity, an AI does not qualify as a person in India under the law that governs patent applications. That seems like a major roadblock before you even get to the inventor part, doesn't it?
It absolutely does. It is the foundational legal barrier according to the source, isn't it? If an AI system doesn't meet the definition of a person under the General Clauses Act, it cannot fulfill the requirement under Section 6 of the Patents Act to even file a patent application in its own name.
Exactly. The legal system simply doesn't recognize it as an entity capable of initiating that kind of legal process or, importantly, holding rights in the first place.
And that definitional problem then cascades down into who can actually hold the patent once it's granted, right? It's not just about applying.
Precisely. It follows logically. Section 2 of the Indian Patents Act defines a patentee, the person who owns the patent, as the person, for the time being, entered on the Register of Patents as the grantee or proprietor of the patent.
Another person.
Another person. And since the definition of person from the General Clauses Act, as cited by the source, excludes AI systems, it means an AI cannot be a person who can be listed as the patentee. So even if, hypothetically, an AI could somehow apply, it couldn't legally be granted or hold the patent in its own name under the current law.
It's like a double barrier then. Can't apply, can't hold. What about the definition of the invention itself or the standard it has to meet? Does the concept of the inventive step play into this discussion as well?
It absolutely does, and it really reinforces the human-centric nature of the current law. Section 2(1) of the Patents Act defines what an invention actually is. It's a new product or process involving an inventive step and capable of industrial application. That concept of the inventive step is crucial.
And how is that interpreted in India, according to the source? Does it relate back to the inventor?
Yes, strongly. The source points out that within the current Indian legal regime, the inventive step is interpreted as requiring human ingenuity. This means that the step forward from existing knowledge, that non-obvious leap that makes something patentable, is understood to be the result of human intellectual effort and creative thought.
Oh, okay.
This interpretation further cements the idea that the inventor must be human, because only a human is seen as possessing the capacity for this kind of ingenuity. An AI system, even if it produces a novel and non-obvious result, isn't seen as performing that inventive step through human-like ingenuity in the eyes of the current law.
So taking all these points together, then, the definition of person under the General Clauses Act, excluding AI, the requirement for a person who is the true and first inventor under Section 6, the definition of patentee as a person under Section 2Y, and the interpretation of inventive step requiring human ingenuity under Section 2(1, what is the consolidated position of the Indian legal system on AI inventorship, based purely on this source's analysis?
Based on the source's examination of these specific provisions and their common interpretation, the current legal framework in India, as it stands today, unequivocally prevents AI systems from being recognized as statutory inventors or being listed as patentees. There's just no room for it in the current wording. The laws were simply drafted for a world where invention was solely a human endeavor, and they are not currently equipped, as written, to handle autonomous AI creativity.
That paints a very clear picture of the current legal landscape in India, a hard no based on existing statutes. But beyond just these sort of technical legal definitions, AI inventorship throws up some incredibly complex, some might say thorny, challenges that the source also delves into. Let's really try and unpack some of these. What's the most fundamental issue once you get past the not a person barrier, assuming you could somehow fix that?
Well, even if you somehow manage to adjust the definition of person by law, the most fundamental challenge is still rooted in that lack of legal entity status. As we discussed, AI is not recognized as a legal entity capable of holding rights or obligations in India or, frankly, in most jurisdictions.
And why is that such a huge practical problem when it comes to patents?
Because intellectual property rights, and patents are a prime example, are property rights. Think of them like owning a piece of land or a building. Ownership bestows exclusive rights, the right to use it, the crucial right to prevent others from using it, the right to sell it, license it, or defend it against trespassers or infringers in this case.
Yeah.
These rights can only be held by a recognized legal entity, either a natural person, a human, or an artificial legal entity, like a company, a university, a government body. If an AI system, which is not a legal entity, is the inventor, it cannot in itself own the patent rights or the exclusive property that the patent represents. There's no it to own it.
Which leads directly to this concept the source raises, the legal void of ownership. That sounds problematic.
Exactly. The source highlights this potential legal void. If the AI is the true and first inventor, let's say it meets the criteria for novelty and inventive step, but it cannot legally own property or rights, who does own the exclusive rights granted by the patent?
Good question.
Does the invention just immediately fall into the public domain, free for anyone to use because there's no owner capable of asserting the exclusive rights? Or does it somehow automatically belong to the AI's owner, its user, its developer? Under current law, there's no clear mechanism to transfer or assign rights from an entity that doesn't legally exist as an owner. This uncertainty is a major problem for commercialization, for investment, and definitely for enforcement. You can imagine a startup whose core product is an AI-generated invention. If they can't secure clear ownership through a patent, their entire business model is, well, pretty shaky.
And we've touched on this before, but current patent law has this really deep-seated emphasis on human creativity. How does autonomous AI inventorship disrupt that underlying principle?
Yeah, it strikes right at the philosophical heart of the patent system, really. Patent law was originally created, and largely still functions, to stimulate human progress by incentivizing individual inventors and organizations employing human inventors.
Right, the bargain.
Exactly. You disclose your invention to the public through the patent, and in exchange you get a limited monopoly, a period of exclusivity to benefit from your effort and ingenuity. This whole system is designed to reward human effort, human insight, human risk-taking. When an invention purportedly arises solely from an autonomous process within a machine, well, the traditional justification for granting that limited monopoly, rewarding human ingenuity, and incentivizing human disclosure gets challenged.
Does the public benefit in the same way? Is the incentive structure still relevant if the inventor doesn't care about incentives?
Precisely. These are the questions it raises. This emphasis on human creativity isn't just a definition in the law, it's tied to the fundamental purpose of why we have patent laws in the first place.
Which brings us to the really thorny question of attribution. If the AI truly invented it on its own, as DABUS claimed, who gets the credit? Or who's listed as the inventor?
This is one of the most complex dilemmas, I think. The source really highlights the difficulties in attribution when the AI is supposedly performing the inventive step. If you can't list the AI under current law, who do you list? The AI user.
But maybe the user just typed in a general prompt and the AI did all the heavy lifting of conception.
Right, or the AI developer. But the developer built a general-purpose system. They didn't necessarily conceive this specific invention that popped out years later. Or perhaps nobody human was truly the inventor in the traditional sense for this particular creation. The source notes that acknowledging AI as a creative source without a clear, transparent, and legally accepted system for attribution is incredibly challenging, because our current concepts of inventorship are so tightly tied to individual human minds conceiving the idea. How do you fit a potentially distributed, maybe even opaque process within a machine into a system that demands identifying a singular, true, and first inventor? It doesn't fit neatly.
And even if you try to sort of bypass the AI inventor issue by saying, okay, the human user or the developer is the inventor, doesn't that just open up another can of worms with messy ownership disputes?
Absolutely. This is another major challenge the source identifies. If you decide a human must be listed as the inventor, who among the potentially many human contributors gets that title and the associated rights? Was it the person who curated the training data, the person who wrote the core algorithms, the person who initiated the specific computer run that led to the invention?
Yeah. Could be a lot of people.
Exactly. If multiple individuals or teams contributed to the AI's development over years, perhaps across different organizations, assigning inventorship for one specific output becomes incredibly difficult and potentially very contentious. The source suggests this could lead to complex legal battles, significant delays, and huge uncertainty in the patenting process as disputes arise not over who invented this particular widget, but over who contributed inventively to the AI system itself that generated the widget. It shifts the fight.
And then there's the whole question of responsibility and liability. This seems critical. If an AI-generated invention infringes on someone else's existing patent, or if a patent granted for an AI invention turns out to be flawed, maybe based on non-disclosed prior art hidden within the AI's vast training data, who is liable? Who pays?
This is a critical piece of the puzzle, and honestly, one without easy answers right now. Traditional legal systems for liability and infringement actions are built around human actors or recognized legal entities. If a human inventor infringes, they or their employing entity are typically liable. If a human-invented patent is found invalid, the human inventor or the patentee faces the consequences.
Right.
But who do you sue if the infringing act or the flawed patent originated from an AI system acting autonomously? The source points out that AI just doesn't fit neatly into these existing liability frameworks. Is it the person who ran the AI at that moment? The company that built the AI system initially? The entity that owns the servers it runs on? Clarifying liability and enforcement mechanisms for AI-generated IP is a significant legal hurdle that absolutely needs to be addressed if AI inventorship in any form were to be recognized.
This also raises a broader, perhaps almost existential concern about the impact on human innovation itself, which the source mentions. What's the worry there?
This is a really significant potential consequence, and one that touches upon the very core incentive structure of the patent system. The concern is, essentially, that if AI systems can rapidly generate a large volume of patentable inventions, potentially far faster than humans can, and these AI-generated inventions are granted the same legal status and value as inventions resulting from intense, often lengthy human effort and creativity, it could potentially diminish the value and appeal of human innovation. If patents for AI-generated ideas start flooding the market, could it become harder for human inventors or startups to compete, to attract investment, or to actually benefit from their ingenuity?
Like an inflation of invention.
Sort of, yeah. The source suggests this could potentially discourage human inventors, undermining the very purpose of the patent system, which, again, is designed to foster and reward human creativity and disclosure. It's a fundamental concern about whether the system can maintain its effectiveness in driving human progress if machines become the primary source of formal registered inventions.
So pulling all these really complex challenges together, the lack of legal entity status, creating that ownership void, the huge difficulty with attribution, the potential for ownership disputes over the AI itself, the massive question marks around liability, and this deep concern about the impact on human ingenuity, it becomes abundantly clear why simply saying, okay, AI can be an inventor under current laws is so profoundly problematic.
Absolutely. It's not simple at all. The source concludes this section by emphasizing that enabling AI inventorship would not be just a simple tweak to the rules. It would necessitate significant fundamental revisions to existing legal rules concerning who can own property, who is liable for actions, how rights are enforced, and how the commercialization of these AI-driven ideas is even managed. The entire legal infrastructure surrounding patents built up over centuries is simply not built for a non-human creator.
Which brings us back to where India stands now. Having seen the global DABUS case unfold, having analyzed its own legal framework and found these clear barriers and understanding all these thorny challenges, India is really at a crossroads, isn't it?
It really is. As we saw from the DABUS case outcomes, there's a global split emerging. You have the dominant position, based on current statutes, requiring human inventorship, that's the US, UK, EU approach. And then you have the less common, potentially more open stance, shown by South Africa, maybe influenced by its procedural system, and arguably Australia, which might be interpreted differently or have different rules evolving.
And India has to decide which path to follow, or maybe carve out its own.
Precisely. India faces that decision. Does it largely align with the predominant international trend, maintaining the strict requirement for human inventors based on its current, very clear legal definitions? Or does it decide to actively forge its own course? And forging its own course would almost certainly necessitate significant legal change, specifically altering its patent rules to somehow accommodate or explicitly recognize AI-driven innovation, either alongside or more radically perhaps, instead of human inventors in some cases.
The source mentions a potential middle ground here, though, right? Something perhaps like a revolutionary than completely redefining inventor overnight.
Yes, it does. The source introduces and explores the concept of honoring AI-assisted inventions as a potential path forward, a sort of halfway house, maybe.
Okay, explain what that AI-assisted model looks like in practice. How would that work?
So in this model, the primary designation of the inventor would remain with a human being. Typically, this would be the person who utilized, supervised, or perhaps directed the AI system in a meaningful way towards the invention.
So still a human inventor listed.
Yes. Crucially, a human is still the named inventor to satisfy the existing legal requirements like Section 6. However, the key difference is that the patent application, or perhaps the granted patent itself, would also formally acknowledge the significant role the AI played in the inventive process.
Ah, okay. So credit where credit's due, but legally, the human is still the inventor.
That's the idea. The human is the designated inventor, meeting the letter of the current law, but the AI's contribution, maybe in generating novel possibilities the human wouldn't have thought of, or performing incredibly complex simulations that led to the breakthrough, is formally recognized in the documentation. It's not hidden.
And what is the source's analysis of this AI-assisted model? Does it see it as a good solution? Does it resolve the issues?
The source suggests this AI-assisted model could be a pragmatic and potentially less disruptive way forward, at least in the short to medium term. Its main advantage is that it largely fits within the existing legal framework, which, as we've established, requires a human inventor.
Right, it avoids needing huge legal changes immediately.
Exactly. By keeping a human as the designated inventor, it neatly sidesteps those immediate, not a person, and can't own rights barriers that listing the AI itself creates. It provides a mechanism to still file for and obtain patents for inventions where AI played a crucial, perhaps even the primary, role in discovery while maintaining legal compliance. It acknowledges the AI's contribution without having to grapple with the massive task of redefining its fundamental legal status as an inventor. It's presented as a way to bridge the gap, basically, and ensure these valuable AI-driven innovations can still enter the patent system and be commercialized, even if the AI itself isn't formally recognized as the creator in law.
So even though DABUS's own patent applications weren't granted in India under the current rules, the whole exercise, the case itself, served as a major catalyst for this entire discussion in India, didn't it?
Absolutely. The source strongly emphasizes that point. The Davis case, despite the specific outcome under current Indian law, really brought to light a significant gap in India's existing patent regulations concerning ideas generated by advanced AI. It forced a confrontation with the issue. The source argues quite forcefully that the rapid evolution of AI technology is clearly outpacing the current legal framework and necessitates an immediate reassessment of policy. The status quo, just relying on laws from 1970, is arguably no longer sufficient in the face of this accelerating technological capability. Things are moving too fast.
So looking ahead, what's the ultimate challenge identified by the source for India and presumably for other nations navigating this complex landscape?
Well, the key challenge for the coming years, as identified by the source, is achieving some form of appropriate legal recognition for AI within the intellectual property landscape. How do we fit this square peg into a round hole, or maybe reshape the hole?
And how might that happen?
The source notes that this necessary recognition could potentially occur through different avenues. One clear path is through legislative amendments. That means Parliament actually changing the text of the Indian Patents Act, or maybe related laws like the General Clauses Act, to explicitly define how AI is treated in IP law, creating new rules.
Okay, changing the law itself.
The other potential avenue mentioned is through judicial interpretations. This is where courts, when faced with new cases, perhaps slightly different from DABUS, might interpret the existing laws in novel ways to try and accommodate AI's role, finding flexibility in the current wording.
Could the court solve it?
It's possible they could make incremental changes, but given the current strict definitions we discussed, like person explicitly excluding AI, and the interpretation of inventive step requiring human ingenuity, the source seems to imply that significant legislative change, actual new laws or amendments, might ultimately be required for a really full and clear framework regarding AI inventorship, or even for properly implementing detailed AI-assisted models consistently. Relying on courts might be too slow or inconsistent.
Okay, this has been a really deep dive into a genuinely complex and, wow, rapidly evolving area. We've seen how the incredible, almost instantaneous creative power of AI is running headfirst into patent laws that were fundamentally built for human minds and, frankly, much slower human processes.
Yeah, we've broken down the specific legal barriers within India, rooted very clearly in the current definition of person that excludes AI systems, and that interpretation of the inventive step as intrinsically requiring human ingenuity under the Patents Act as it stands.
And we've really explored the profound challenges AI inventorship throws up that legal void of ownership if AI can't hold rights, the sheer difficulty in attributing inventorship fairly, the potential for really messy disputes over who contributed to the AI's creation, those big unanswered questions of liability if something goes wrong, and maybe most fundamentally, the significant concern that a flood of AI-generated patents would actually devalue and discourage human creativity, the very thing the patent system was designed to foster.
Mhm. And India, like many countries globally, is actively grappling with these issues right now. It's weighing the options between maintaining its current alignment with the majority view that requires human inventors or deciding to forge a new path, likely through significant legal reform. The source highlights that AI-assisted model as a potentially pragmatic step, maybe a bridge, that could work within or with minimal changes to the current framework.
A temporary fix, perhaps.
Potentially, yes, but it also emphasizes that the sheer speed of AI development demands an urgent policy reassessment regardless. Kicking the can down the road might not be viable for long.
Which really leaves us with a fundamental question, doesn't it? One that kind of lingers after this deep dive. If AI systems can truly generate novel, patentable inventions on their own, does the very concept of inventorship, as enshrined in our laws for centuries, need to be fundamentally redefined? And what does that imply for the future? How do we continue to incentivize and reward human ingenuity, which has been the historical bedrock of the patent system, while also embracing and integrating these incredibly powerful creative tools like AI? How do we ensure the patent system continues to benefit society by promoting disclosure and innovation, regardless of whether the initial spark of invention came from a human mind or an artificial one? And that's a huge balancing act, isn't it? And it's one nations like India will be navigating very carefully in the years to come. It really makes you think about what it even means to be a creator in the 21st century.